Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and I'm joined today by our host Jim York and his guest Celia Deifik, real property lawyer with Lanier and Deifik.
Thank you, Morgan, for the introduction. Well, Cecilia, thanks for coming on the show. For the people that have not seen you or heard of you, tell us a little bit about yourself. I know you're one of the top litigators for real estate in Naples. So,
well, I'm not going to say that I'm one of the top. I mean, I think I'm, certainly very well versed. I litigate real estate and business issues. I've been board certified in real property law since 1990, which means that I'm recertified every 5 years by the Florida Bar, which is an indicia of continuing knowledge, expertise, and reputation. I've practiced almost 40 years. We won't get into exactly how long.
Right.
I've been with the law firm of, currently it's Lanier and Deifik. We've been together over 20 years, and we're located downtown. So years ago, I would write condominium documents, help convert condominiums to, co-ops to condos.
That's right, that's what you were saying.
Do mortgage loan and real estate loan transactions. These days I don't do any transactional work, but that experience has been invaluable. So all I do is litigate, and I'll litigate anything that has to do with dirt, basically. And that would mean community association disputes, including condominiums and HOAs, real estate contract disputes, residential and commercial, plat reformations, covenant reformations, challenges to covenants, all kinds of things, brokerage commissions.
Well, the bottom line is anything that's disputed, you're good at. So
Well,
thank God I haven't had to use you. But let's get on to the topic here today, is that we have a neighbor that you have a dispute with. They've built something on their property, or they're doing something, and
it's encroaching on yours.
Exactly, or whatever. They're playing music loud at night, midnight, or whatever, and you tried to resolve it yourself with them, but it didn't work, so they've contacted you. So where do we go from there?
Well, first we need to identify what kind of community they are in and what are the applicable covenants, if any. And I think we're all familiar with condominiums and homeowner associations. And we tend to think of homeowner associations as those which are formally incorporated under and compliant with Florida Statute Chapter 720. But in fact, there are communities that have covenants, but they really are not compliant with and not subject to that Florida statute. And so they might have their own association, but the association is not technically a homeowner association. We also have communities where there's covenants but no association.
True.
Now, so we look at those covenants first.
We identify them.
We identify the community, we
have
identify the covenants, and one of the things I find is clients will come in and they'll bring me the covenants or the condo deck that was given to them when they purchased 10 years ago. That's not what I'm going, or 20 years ago. That's not what I'm going to rely on. I'm going to get an updated set from the public records, get my abstractor to pull it.
Because people could have done an addendum to those.
They might have been amended. They might
right.
have been amended and restated.
Yep.
All right? So first we're going to look at those covenants and see what the remedies are in the covenants and the applicable statute, if there is one. And first we might ask the board to enforce the covenants against the neighbor. Now, a lot of people don't realize that under condominium and HOA covenants, they have what we call a private right of action, which means you're my neighbor and you've built your garage over my lawn. I can sue you without going through the board. Now, I might have to go through mediation or arbitration first. But the more interesting thing that you and I were discussing is, what do you do when the covenants are insufficient or expired? And we're seeing more and more in the state of Florida that covenants have lapsed because of the application of something we call the Marketable Record Title Act.
Right.
And you don't really need to remember that term. What you need to know is that when covenants are not properly referenced repeatedly and kept current in title instruments, they may be deemed to have expired. So what can you do then? Now, again, the covenants are my first line of defense, because the covenants usually not only spell out where the setbacks have to be, that people cannot create a nuisance, people cannot block your line of sight or block your driveway.
Right.
They're also going to give you a right to attorney's fees if you prevail. But again, what do we do when those covenants are insufficient or expired? Well, then we might look at the zoning code of our relevant municipality, the county, the city of Naples, city of Bonita Springs, those kinds of things. And there we might find that there's a code restriction against whatever the neighbor is doing.
Right.
And so we take it up with the code enforcement people. Well, sometimes that's very effective. Sometimes they are otherwise occupied and it's not as important to them as it might be to you. So then the question arises, do you have a private right of action, a private right to bring a lawsuit or make a demand against a neighbor for their failure to comply with a city's zoning code,
right,
or a county zoning code? And that is an issue that has been kicked around in the courts for a while. And it's enjoyed a new look now because we're seeing more communities where the covenants have expired.
So if somebody has a problem like that, how are they going to know all this? They should go to you first or go to an attorney, because they're not going to understand all this, right?
That certainly may be.
Then you would give them the options of,
yes,
this is what we could do. The covenants have expired, or whatever the case might be, correct?
And what I always try to do is give clients some tools so they can try and solve the problem themselves
first.
Cheaply
Right.
first. Because I certainly don't want to take their money and bring a lawsuit when there was a simpler
way
remedy.
Of doing it. Right.
All right? So I might say, well, it appears the covenants have expired, but here's the local zoning code,
Right.
and your neighbor's not in compliance with it. Have you called the code enforcement office? And sometimes you can work through the code enforcement office, and occasionally something comes up before the code enforcement board. I was on the Collier County Code Enforcement Board, 20 years ago or so. So I know that often the city or the county can take care of things. But if you come back to me and you say, nothing's happening, it's not getting resolved,
Right.
then we look at, can you make a demand on your neighbor to comply with the zoning laws, and can you force your neighbor and the city or county, whatever it might be, to comply on your own without the city taking action? And the answer is a qualified yes. There are cases that say that you can sue to enforce a zoning code. Usually in that scenario, you would sue your neighbor, who you believe to be non-compliant, and you would sue the city. Now, you're not looking for damages, you're looking for an injunction to compel him to move his garage, take down the screen of trees or fence that's blocking your view, or causing excessive noise because he's put in all kinds of machinery, those kinds of things. Now, the standard has been in doubt and bantered around by the courts over the years. And one of the reasons that you and I were talking about it is there's a very, very recent case, came out in October of this year, and it's in our appellate district, which it means it's governing for the trial courts here. Mm-hmm. And basically what it says is that a private owner has a homeowner has a private right of action against the neighbor and the city to compel action if the homeowner can show what's called special damages.
Right.
Special damages would be that your property value has been diminished or part of your property has become unusable. And what is significant about this case is the courts previously in Florida have been kind of hostile to this idea, and they would say, well, if the zoning grievance is such that it affects the whole community or everybody on the street, then homeowner A, let's just say it's Celia,
right,
doesn't have a specific cause of action. But what the Second District Court of Appeal is saying now, and that's kind of our umbrella appellate court, is saying, well, maybe it affects other people on the street, but if it's particularly affecting Celia and diminishing the value of her property, then she can bring that suit.
Right.
And they go a step further and say, even if Celia's property is appreciating, and her house is worth more this year than it was last year before the zoning problem, if it's still diminished compared to other similar homes on the street because of what obnoxious neighbor has done, she has a particular problem and can prove special damages and should be entitled to an injunction. Now, of course, you need to make sure that your facts are correct before you run off and do this.
Yeah, that's very interesting. I mean, the way you laid it out for a person, you know, if they have a dispute, there are different options that they can do, and, you know, I really appreciate it, and we're going to do some other stuff, talk about some other subjects here today, but before that, we're going to take a little short break and hear about the York Real Estate Group and be back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Welcome back. Well, Cecilia, I guess we were talking during break here, and you wanted to do another little segment on, you know, what real estate, or really attorneys talk about family issues when people are going through a divorce, and you just wanted to touch base on some of the things that they're missing out on, right?
Sure. I did a seminar last week that was pretty well received for divorce attorneys, for family law attorneys, and it was basically real estate tips for real estate attorneys, things they might not think about, okay? And among those are trying to make sure that the language in their settlement agreements are really specific, and that if it concerns the price at which they'll let property go, they don't put that in the settlement agreement that's going to get attached to the judgment. It should be a side agreement so that your buyers and realtors don't see that. The other thing that we talked about is agreeing in advance to the use of a special magistrate, because when things blow up later, no one's going to agree. But if you put in your divorce agreement that if we have disputes about how we're going to market the house, how we're going to list the house,
right,
how we're going to sell it, any real estate, but often it's about the marital home, that we're going to agree now that the court can appoint a special magistrate, which is often, I call it Mr. Calm Professional.
right. Mm-hmm.
It could be an attorney, it could be a CPA,
That's right.
it could be even a real estate broker, who will be authorized to take steps, logical, reasonable steps,
Mm-hmm. Without the emotion.
without the emotion. The other thing we talked about is preserving clients' homestead interests. Mm-hmm. And I think a lot of family law attorneys are not as well aware as real estate attorneys are of some of these things. And I was on your show a couple of years ago and we talked about homestead. And Florida homestead is very misunderstood, particularly by people who move here from out of state. There's three basic aspects. Shielding property from creditors. Your
Mm-hmm.
homestead is
That's
exempt
right.
from creditors.
Mm-hmm.
Restraints on alienation. You can't sell your house without your wife's joinder,
Mm-hmm.
even if she's not entitled.
Right.
And the tax exemption. Now, most people, particularly that come here from out of state, they focus on the tax exemption.
Mm-hmm.
That's really only one aspect. So what do you need to think about, or your divorce attorney think about, when, God forbid, you're going through a divorce? Well, you want to preserve the homestead character of any proceeds from the sale of the house. So let's say the parties have decided they're going to sell the marital home and they're going to split the money, and they each go their separate ways, and
Right.
they may want to buy other homes
Mm-hmm.
here in Florida. Well, the proceeds from that house enjoy the same protection that the house does. It's exempt from creditors, as long as you keep it separate.
Separate.
As long as you keep it separate. Now, something that's become a big issue that people haven't thought about in the last 2 years since Hurricane Irma is insurance proceeds for the house, to replace your roof
Right.
or
Mhm.
fix your house because of hurricane damage. Those insurance proceeds are homestead. And as long as you keep them segregated as your homestead monies,
Right.
they're exempt from attachment from another creditor. Let's say Ford Motor Company has a judgment against
Against you,
you, or
right.
Sears, or
Whatever.
yeah, whoever it might be. They can attach your bank account. They can garnish your wages to a certain extent. You have certain protections, but they can't touch your homestead property. And that means the insurance proceeds that you've put in a separate account.
No.
The other thing divorce attorneys sometimes trip up on is they will say, oh, these people have they have these judgments and debts, so once we sell the house, they're going to pay those off, and they put that in the agreement.
Mm-hmm.
Well, they've just blown up
Blown up. Right.
the homestead character of the proceeds. You want to be really cautious not to say that the proceeds of the house, presuming it's homestead,
Right.
really cautious not to say, oh, you have to pay off these judgments and pay these debts and pay these credit cards.
Right.
Because then it's not homestead anymore. Now, the other thing that I think divorce attorneys or people going through divorce don't think about is the Save Our Homes portability benefit,
Right.
which is divisible. And for people who are not familiar with it, I don't know, like 3 decades ago, we had an amendment to our Constitution that said we have too many people encountering severe financial stress because the value of their Florida property
It's gone up.
has gone up so much, which makes their taxes go up.
Right.
And so the Constitution was amended in the Save Our Homes Amendment to say your taxes on homestead property, doesn't
Right.
apply to other
That's
property,
right. Yep.
will only go up 3% a year. Even if your property value jumped 30%, your taxes will go up 3%. Well, over the years, that adds up. I've been in my home for a few decades now. There are people in my neighborhood paying this for their taxes, and people who bought recently, same type of house.
Right, it's way up there.
Way. I mean, there could be $6,000 or more difference per year in what people are paying. Now, about 10 years ago, the legislature recognized that people were reluctant to take jobs and move because they didn't want to give up that benefit. Because I have a 3,000 square foot house in Naples, and I want to move to Miami to take a job.
Right.
Same house, my tax bill would quadruple.
Sure.
So they made that tax benefit portable. You can take it with you. So what people don't think about when they're going through a divorce is, you can take it with you.
Right.
You can divide it,
Right.
and it has value. So for instance, a divorce attorney contacted me just yesterday and said, well, what if one spouse is leaving the state and one spouse is staying? Well, the spouse that's staying is enjoying a very significant asset, because their taxes stay low. So you might want to calculate the present value of that over years and somehow compensate
the other
spouse.
Right.
Now it works the other way. Let's say that you're a divorce attorney and you're going to do a prenup for some people, a prenuptial agreement.
Right.
And she's got a home in Fort Myers and he's got a home in Fort Lauderdale, both homesteaded,
Right.
both enjoying Save Our Homes tax lowering. They want to sell both those homes and buy one house in Naples. They can port their savings from their old homes and combine them. So it's a valuable asset, and those are some of the kinds of things that you want to think about when you're...
You know, I think that was a great segment. I mean, really, I don't think people, the other attorneys, no offense to them, it's nice to have a group of people around you thinking of, what could happen or what can't happen, and have that all part of your settlement, because they're not experts in real estate.
Right.
They're experts in other things.
Right.
Nothing against them.
Right, they're experts in their discipline.
Just like our business, we think we're experts in real estate.
Well, I think you are.
But, we rely on you or other attorneys or insurance people on their expertise. So it's about putting the team together. But I thank you for coming on today, Cecilia, and hopefully you come back soon and give us another great subject, okay?
Right.
Thank you for tuning in. We'll see you next week. Thank you.